Are we reaching a turning point on the war against crypto? And is it a war? Because 4 minutes ago, the prediction that Crypto Law and I made a long time ago was that they're coming for the exchanges, they're coming for everyone. If this case gets up to the appellate court, Ripple's chances get way better.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel.
Are we reaching a turning point on the war against crypto? And is it a war? Because 4 minutes ago, the prediction that Crypto Law and I made a long time ago was that they're coming for the exchanges, they're coming for everyone, and Justin Sun just got sued by the SEC as well. But this turning point that I'm talking about, it doesn't happen until we get someone else other than the SEC and Gary Gensler with authority to speak. And now we're getting that. I said that the war on crypto will be won in the courtroom. And that's where it's going to be fought, and that's where it's going to be won, because the SEC and Gary Gensler may not have a faithful allegiance to the law. They can ignore 80 years of case law, but you know who won't? Judges won't. They will have a faithful allegiance, and they're not going to do the same thing. Now, every court battle that we've seen, every single one, has proved an injury, not a fatal injury, but an injury to the SEC's credibility, which will lead to an injury in its ultimate authority in this war. Legitimate crypto is going to win. Look at what I mean. The library hearing, the SEC wanted it to be completely vague. They wanted the ruling to apply to secondary market sales. We go in there, we fight, we make our argument, we bring the facts, we bring the law, and the judge said he will make sure that his decision states that it does not apply to secondary market users, secondary market sales. And he is critical of the SEC and frustrated. And you're going to see that when you read his opinion, hopefully, and when you read the transcript. There's an injury. The Ripple case, Judge Netburn, quote, the SEC lawyers are hypocrites and they lack a faithful allegiance to the law. And then you have Judge Torres saying, you know what? I'm not going to let you to bring this expert in who's going to do what I call swag. That's scientific wild ass guesses and just say, oh, I know what the minds of the XRP holders were when they purchased XRP. Although I haven't interviewed a single XRP holder in the world, let me tell you, the judge said, no, you're not going to say that because I'm not going to allow it. Grayscale, right? The judge is saying to the SEC attorneys, you don't make any sense. Everything you said about a futures Bitcoin ETF equally applies to a spot Bitcoin ETF. And then they argued, and the judges said, but you haven't claimed that Grayscale's analysis is wrong or inappropriate. You just want us to not do it because you don't want us to do it. And I think we're going to see, I predicted Grayscale will win. We'll see if that comes true. And then finally, just recently, the Voyager case. And the judge taking the SEC to battle. Each one of these, there's another injury in the battle to the SEC. And some of you think, well, what's this got to do with Ripple? What's this got to do if I'm an XRP holder? Why did Ripple file supplemental briefs? Right? They filed a supplemental authority, a letter to the judge that says, we want you to be aware of something. And Ripple has done that twice, very recently. Okay. For some of you that don't know, all it is when all the briefs are written and there's no more oral arguments and you're waiting on a decision from the judge. Supplemental authority is when a party like Ripple writes a letter that says, Judge, please be aware that this decision just came down and this is what the judge said because it's relevant to the issues that you're deciding right now. Ripple did that twice. And I'm going to talk about both of them briefly. The first one was the Voyager case. And what happened? The judge rebuked the SEC for being vague. The SEC wanted to come into their court and say, we object to the sale. We do not believe, Judge, you should authorize this sale in this bankruptcy court because we believe that the VGX token has characteristics of a security. We think it might be a security. And the judge said, well, tell me about why. And they said to the judge, well, we'll tell you, but we want it to be in private. And the judge wouldn't have that. You're a public agency funded by the U.S. taxpayer. Whatever you have to say, why can't you say it in open court? The judge wouldn't allow that, okay? And the judge said, no way, say it in court. But the SEC refused. They offered no guidance to what Voyager had to prove. They wanted Voyager to prove that the token was not a security. And the judge said, that's not how it works. You are an enforcement agency. You need to prove it. And they could offer no proof. And the judge rejected the idea. What he said is, quote, reject the idea that these debtors are supposed to figure out for themselves just what aspects of a VGX token might possibly be considered to be aspects of a security. The judge pointed this out to him. Now, does that sound familiar? What is the defense in the Ripple case? Ripple has highlighted the vagueness of the SEC. The judge, Ripple has said the same things, that how can I, Chris Larson, Brad Garlinghouse, Ripple, know what the law is if you won't tell us what the law is? And on top of that, you can't figure out the law yourself. In fact, the judge in the Voyager case said, quote, crypto companies operate in a regulatory environment best described as, quote, highly uncertain. He said regulators themselves can't agree on whether crypto is a commodity governed by the CFTC or a security governed by the SEC. He said they can't even make up their mind what criteria you use to determine which agency should be the one that governs the tokens. And so how does that apply? Well, the same thing that Ripple was arguing, right? How can you say XRP is a security when SEC enforcement lawyers could own it all the way up to 2019? How could you say that XRP is a security when Hinman said that if it's sufficiently decentralized, the prior initial sales or ICO doesn't matter? And you believe that XRP is sufficiently decentralized. How do you know where the law is? And that's what happens. And so he took the SEC to task, and that helps Judge Torres if she feels the same. Imagine Judge Torres agreeing with Judge Netburn that there's a lack of faithful allegiance to the law and that the SEC lawyers are hypocrites. Well, the judge, here's another court and another court taking the SEC to task, and it gives another judge confidence that she's doing the right thing as well. Now, I promised you all in a tweet, I teased you and said that I was going to share something with you, connect some dots for you people out there that no one else has done. And I'm going to go back to Ripple's first supplemental authority letter. That was involving the U.S. Supreme Court in the Bittner versus United States. And Justice Gorsuch, joined by Justice Jackson, elaborated on fair notice and the fair notice defense. And Justice Gorsuch said that the government must provide, quote, fair notice of what conduct is prohibited, that due process under our Constitution requires the government to put you on notice of what conduct is prohibited and unlawful. The government must prove to a common man a fair warning in common language of what is not allowed. Same exact thing in the Ripple case. Now, what's the dot that I'm connecting? Do you know who Justice Gorsuch is? Do you know what law firm Justice Gorsuch comes from? That's right. Justice Gorsuch, before being on the U.S. Supreme Court, worked at the law firm hired by Ripple. Michael Kellogg is the founding partner and is the main attorney that was responsible for Ripple's appellate brief, their district court brief that I call an appellate ready brief. Michael Kellogg, who used to be Neil Gorsuch's partner and possibly boss, because he's the managing partner, wrote about fair notice, and now Neil Gorsuch at the Supreme Court is writing about fair notice. How about that? Now you understand why I say to you, as this case gets up to the appellate court, Ripple's chances get way better, not because of those connections, but because it's the law, and the law should be what wins. And the SEC's best chance is at this level of the court.